Apparently Isaac Hayes, yes, the songwriter and musician, has done what the entire Justice Department could not. They've gotten former President Trump to shut up. Yes, this is the confluence of presidential law and musical copyright. I was born for this. Because this just in, none of the cool kids want Donald Trump using their music in his campaign. Foo Fighters, Queen, Celine Dion, Panic at the Disco, R.E.M., Guns N' Roses, Bruce Springsteen, and Pharrell Williams, among many, many others, objected to Trump using their music during his campaign. Which is surprising because Trump has musical superstars like Ted Nugent and Kid Rock. End of list. But the Trump campaign got into a dispute with the estate of Isaac Hayes, and the estate of Isaac Hayes won. But this suit might be the first of many, given that the White Stripes have filed a similar suit just shortly thereafter. With the caption, "This machine sues fascists." A federal judge in Atlanta just ruled that Trump and his campaign must stop using the song "Hold On, I'm Coming," while the family of Isaac Hayes pursues a lawsuit against Trump for unauthorized use. Hayes was the co-writer of the song, and his estate has repeatedly objected to Trump using it as his outro music. Yes, apparently Trump typically enters the stage to "Proud to be an American" by Lee Greenwood and exits with "Hold On, I'm Coming." A classic business in the front and party in the back situation. But after Trump used the song "Hold On, I'm Coming" over 133 times, the Hayes estate got fed up. On August 9th, Trump live-streamed a campaign rally where he used the song as his outro music. A few weeks later, the Hayes estate filed a lawsuit seeking an emergency injunction that would stop Trump and other groups from allowing the public performance of the song at all Trump-related events. Quote, U.S. District Judge Thomas Thrash ruled that Trump must stop using the song, but he denied a request to force the campaign to take down any existing videos that include the song. So how did we get here, and how did the estate of Isaac Hayes win? Well, Isaac Hayes was an influential American singer, songwriter, composer, and actor who's best known for his deep bass voice. Hayes was a key figure in Stax Records, where he worked as an in-house songwriter, session musician, and record producer. Hayes co-wrote many hits for other artists, including the iconic song Soul Man by Sam and Dave. And his groundbreaking work for the soundtrack to the 1971 film Shaft won him an Academy Award for Best Original Song. The song Theme from Shaft is one of the defining tracks of the blaxploitation film era. And some of you probably know Hayes from his role as the character Chef on South Park.
Oh boy, here we go again.
Now, Hayes passed away in 2008, and when a musician or songwriter dies, the copyright in the person's music usually becomes the part of their estate, which may include family members, heirs, or designated beneficiaries as specified in the person's will. Now, after the person's death, an executor or administrator is responsible for managing the estate, including any musical rights. This person or entity may be responsible for licensing the music, collecting royalties, and ensuring that the rights are properly managed. If the person had a publishing deal, the publisher might continue to administer the rights depending on the terms of the contract. And the estate typically continues to receive royalties from those arrangements. Now, in the United States, copyright lasts for the life of the author plus 70 years. And during this period, the estate or rights holders control the music and continue to license it, collect royalties, and enforce copyright protections. After the copyright term expires, the music enters the public domain, meaning it can be used by anyone without the need to obtain permission or to pay royalties. Now, there are many, many nuances and exceptions to these rules, especially when it comes to pre-1976 music. But for more of the legal flavor about the duration of copyright, especially as it regards musical works, you can see the videos that we've done about the copyright law and Taylor Swift. So the estate or rights holders can continue to license music for various uses and collect royalties. The estate can also take legal action against unauthorized use of the music, just as the original artist could have while they were alive. And while courts hate issuing injunctions and telling people they can't do anything and using the force of law to prevent them from doing something, in the context of art, including musical works, it's one area where courts often issue injunctions forcing people to do or not do something. And the reason is that when it comes to unauthorized use of using someone's IP, courts consider that often to be irreparable harm, which is one of the ways that you get an injunction, which we'll talk about in a moment. And the song Hold On, I'm Coming was co-written by Hayes and David Porter. It's been sampled many times over the years by artists who obtained licenses, including Aretha Franklin, Tina Turner, Cynthia Enviro, Eric Clapton, B.B. King, and most famously by the duo Sam and Dave. We'll talk about them in a minute because you'll never guess, how they factor into this story. But the Sam and Dave version is the version you've probably heard. It sounds like this. Now, if a political campaign steals your song, you'll want a great lawyer, and my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your social security number had been hacked, or are dealing with a workers' compensation or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can get the best representation, maximize your recovery, and find out what your options are. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So you can click on the link below. Now, the Hayes estate alleges that Donald Trump, quote, began publicly performing the copyrighted work in 2020 as outro music for appearances and campaign events. According to the complaint, a cease and desist letter was sent to the Trump campaign in 2020 by non-parties Universal Music Group and Warner Chappell Music, publishers contracted by plaintiff Isaac Hayes Enterprises. Defendants have never sought the permission or consent of plaintiffs for any use of the copyrighted work until 2024, nor have they obtained a valid public performance license for the same at any point. Yeah, you might not know this, but if you want to publicly perform, i.e. play someone else's song at an event, you need to get a license to be able to do so. Now, the plaintiff claims that Trump used the song at least 133 times since 2020. Then, on August 9th, 2024, Mr. Trump live-streamed one such campaign rally in Bozeman, Montana, which is still available on Mr. Trump's Truth Social account. The Hayes estate says, quote, the infringing video therefore makes unauthorized use of the composition and the recording and infringes upon plaintiff's copyrights in both. Clips from these events have appeared all over the internet, including on, quote, YouTube, Facebook, Twitter, Truth Social, Instagram, and Rumble, whatever that is. Now, there's one more wrinkle to this case, and that is that Sam Moore, better known as one half of Sam and Dave, is a devoted Trumpist who played at Trump's first inauguration. Now, the Dave of Sam and Dave, Dave Prater, passed away in 1988. Now, interestingly, although Moore performed the song, he doesn't have any legal interest in the song, which he did not write. Now, when it comes to music, there's generally two important copyrights. One is the composition copyright, and the other is the master recording copyright. The composition copyright is the copyright in the lyrics and the melody and the notes as laid out on, like a sheet of paper. Whereas the master recording copyright is the copyright in the music as it's recorded onto tape or vinyl or whatever it is that they recorded back in the day. And those are two different copyrights, and different people can have the rights in both of those different copyrights. And here, although Sam and Dave actually performed the song as it was recorded in the most famous version, it doesn't look like they had any rights. It looks like they assigned all of their rights to the music publisher Stax at the time. And the Copyright Act allows original artists, in this case Hayes, to terminate assignment of pre-1976 copyrighted works, which is how a lot of bands who lost or never had the copyright in their own music got their ownership back from their labels. And it looks like that's exactly what Isaac Hayes did. So I'm guessing his estate is probably going to win the chain of custody dispute. Meanwhile, Isaac Hayes, as the composer of the song, still retained his composition rights. And apart from that, it looks like Isaac Hayes might have had the rights in the master recording anyway, because he was the arranger and producer of the Sam and Dave version. Who knew? Music is a small world, and Isaac Hayes was apparently really, really talented. But regardless of who owns the actual copyrights, Trump's lawyers say that it wouldn't cause irreparable harm to the memory of Isaac Hayes to play this music at a Trump rally, because Isaac Hayes was a registered Republican who once performed at Lee Atwater's high school reunion. And Sam Moore submitted a letter to the court saying that, in his opinion, Hayes would be delighted for Trump to use the song. But that doesn't really matter since Hayes is no longer with us. The issue is A, whether his estate is one of the license holders for the song, and B, whether his estate granted the Trump campaign a license to perform the song. And the complaint alleges that Trump infringed on the Hayes estate's copyright in the composition of the song. U.S. copyright law gives the owner of a composition the exclusive right to perform the work publicly or to authorize others to do so. It's right there in the Copyright Act. 17 U.S.C. 106 says that the owner of a copyright has the exclusive rights in, quote, the case of sound recordings to perform the copyrighted work publicly. And to perform or display work publicly means to perform or display at a place open to the public or at any place where a substantial number of persons outside of a normal circle of family and its social acquaintances is gathered. So in case you were wondering, no, playing music at your own backyard barbecue probably doesn't violate anyone's copyright. But public performance does include playing the composition in a public place where people other than family and friends are present, broadcasting it on radio or TV, and streaming it online. So therefore, to do that, you need a license. Trump claimed that he had a license to play the song from BMI, which has a division that licenses songs to political entities. However, the Hayes estate alleges that Trump did not have a public performance license or permission to perform the song publicly. They cited a letter from BMI's political entities division to the Trump campaign. It states that Hayes' co-writer, David Porter, instructed his music publisher, Universal Music Publishing Group, that he objected to Trump using the song. BMI warned Trump that the song was being excluded from the agreement between Trump and BMI for licensure of songs for his campaign. The letter said, quote, BMI will consider any performance of the works by the Donald J. Trump for President 2024 campaign from this date forward to be unlicensed and material breach of the agreement for which BMI reserves all rights and remedies with respect thereto. In response to the lawsuit, the Trump campaign said, quote, the campaign obtained a music license for political entities or organizations effective November 30th, 2022, which authorized the campaign's use of Hold On, I'm Coming. Not only is plaintiff's evidence insufficient, but it is rebutted by the implications of BMI's issuance of a license to the campaign, Declaration of Justin Caparelli, and the Declaration of Sam Moore, in which he explains, based on his intimate familiarity with the facts, exactly what the copyright history of the song actually is. This is sufficient to deny plaintiff's motion. But we can look to the contract between BMI and the Trump campaign. Paragraph 2A of the agreement says that the work may be excluded from the agreement if one or more of the songwriters gives notice to BMI that, quote, such songwriter objects to the use of the copyrighted works for the intended uses of the licensee. BMI shall provide written notice to the licensee of any such exclusion. And further, any use of the song after receipt of the notice is considered a material breach of the agreement. And the Hayes estate also sued other organizations for contributing to the infringement by hosting events where the song was played. This includes Turning Point USA for allowing Trump to use the song at several of its campaign events. Trump used the song at the Turning Point USA conference in Florida on July 15th. It racked up over 1 million views on YouTube. The estate added the National Rifle Association as a defendant for allowing Trump to perform the song at several of its events, as well as the American Conservative Union, the Republican National Convention, and the Bitcoin Convention for doing the same thing during Trump's speeches at their events. But after all this, federal judge Thomas Thrash granted the Hayes estate a preliminary injunction prohibiting Trump from using the song. Now, the federal standard for a preliminary injunction is outlined in Rule 65 of the Federal Rules of Civil Procedure, and courts typically require the moving party to satisfy 4 key factors to obtain a preliminary injunction, because the law considers them to be pretty serious. So the plaintiff must show a reasonable probability or likelihood of success on the merits. This means that the plaintiff can demonstrate that it has a plausible legal claim and sufficient evidence to back that up. The plaintiff has to show that if the injunction isn't granted, the plaintiff will suffer irreparable harm that can't be remedied by money damages or other relief. That's a lot easier to show when it comes to IP as opposed to usually like a breach of contract, where if you can be made whole by just being given money, then that doesn't qualify as irreparable harm. The court then weighs the harms both parties will suffer from an injunction, and the court considers the harm the defendant will suffer if the injunction is issued versus the harm that the plaintiff will suffer if it doesn't. And finally, the court considers whether there is any public interest at stake, meaning whether the injunction will benefit or harm the community in general. And in this case, the most important factor is probably the first one, whether the Hayes family can show that it would probably win at trial. Judge Thrash made his ruling from the bench saying, quote, I do order Trump and his campaign to not use the song without proper license. Now, since there's no written order, we don't have more information at this time, but the judge obviously believed that the Hayes family could show that it did have a legal interest in the song and that it did not give the Trump campaign permission to use it. Now, obviously, the Trump campaign asserted that the campaign's agreement with BMI's music license for political entities division gave them the right to use the song, but Judge Thrash reviewed the contract terms, specifically paragraph 2A, and he must have felt that the Hayes estate could show ownership of the rights and that the agreement gave it the right to exclude the song from the license. And the Hayes estate argued that it had suffered irreparable harm in the form of damage and injury to their business, reputation, and goodwill, and argued, quote, plaintiffs will continue to sustain substantial loss of revenues, profits, and goodwill unless defendants are preliminarily and permanently restrained and enjoined by the court from further false endorsement and or advertising. Now, Trump argued that the estate couldn't show irreparable harm because it waited 4 years to object to the use of the song, but this is a factual dispute since Hayes' son said the estate had been objecting to the use for years.
He wrote songs that were the soundtrack of the 60s and the civil rights movement. Hold On, I'm Coming, and Soul Man, those records were part of that, and that's extremely important. That song is one of the gems of our catalog, and it's licensed, plenty of times every year, and that was the point about this injunction, is the fact that I don't want that song politicized in any way.
Trump also argued that using the song implicated core political speech, but Judge Thrash found that if Trump continued to use the song, that it would harm plaintiff more than Trump. However, the judge denied the estate's motion to force the Trump campaign to remove all the videos of Trump dancing off the stage to the song. And the Trump campaign alleges that the Hayes estate doesn't actually own the copyright for the song. But a preliminary injunction is only temporary. The parties will continue to litigate the case. The Trump campaign would stop using the song and that they were very pleased that the judge didn't order the videos to be removed from the internet. So while this is a victory for the Hayes estate, it's not quite the victory that many have reported. I've seen a lot of people reporting on this, that the Hayes estate won $150 million from Trump in the Trump campaign, but that's simply not correct. The merits have not yet been decided. This is certainly a victory, but it's a preliminary one, and we'll see who actually wins the compensation at the end of this case. And in a similar case, now Donald Trump has been found liable for copyright infringement after using a 40-second clip of Eddie Grant's 1983 hit Electric Avenue in a 2020 campaign video without permission. Trump's campaign video looked like this: a visual depiction of a red train moving swiftly through a snowy landscape and bearing the words Trump Pence CAG 2020, and a handcar bearing the words Biden President Your Hair Smells Terrific, being powered by an animated likeness of former Vice President Biden. The song Electric Avenue played alongside embarrassing clips about Biden.
So I learned about roaches. I learned about kids jumping on my lap. And I've loved kids jumping on my lap.
The video was viewed 13.7 million times before Trump took it down. Grant then sued Trump for infringement. During the case, Dan Scavino gave deposition testimony that the Trump campaign account took the video from a random person on the internet. Quote, Scavino testified that he saw the video on a Trump supporter's social media page, either on the same day or the day before he posted the tweet. Scavino also testified that he spoke with former President Trump before posting the tweet, and that former President Trump let him go with his instinct on it and post it. Former President Trump testified that the video was taken from the internet and posted on Twitter. And after more than 4 years of legal proceedings, a federal judge ruled in favor of Grant, rejecting Trump's fair use defense. Quote, in this case, the video has a very low degree of transformativeness, if any at all. As this court found in denying the defendant's motion to dismiss, the video is at best described as a wholesale copying of music to accompany a political campaign ad. The video's creator did not edit the song lyrics, vocals, or instrumentals at all, and the song is immediately recognizable when it begins playing around the 15-second mark of the video, notwithstanding the audio of President Biden's speech can be heard simultaneously. Moreover, the animation does not use Electric Avenue as a vehicle to deliver its satirical message, and makes no effort to poke fun at the song or Grant. So the judge ruled that Trump is liable for infringement, and there will be a trial on damages. Now, the complaint also includes counts for false endorsement under the Lanham Act and a violation of Georgia's right of publicity laws, and they're seeking statutory and punitive damages, as well as an injunction to stop further unauthorized use of the song. The lawsuit demands an accounting of profits earned from the unauthorized use and seeks destruction of all infringing copies of the videos featuring the song. So you can bet they will still be arguing over this long after Trump is elected president or not elected president. So until then, those lawyers are going to be working some late nights, and I'm sure they'd really benefit from having some delicious late night dinners at the office, which they can get with today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things you actually want to do. You can choose from over 35 different options a week, including ones that are keto, calorie smart, vegan, and veggie, and more. And on top of that, Factor offers lots of snack options for when you don't need a full meal. And Factor meals arrive at your door pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I can even think about going to the grocery store, my Factor meal is already done. Because sometimes I just want a good, healthy meal without having to cook. And it's the perfect workday dinner. It's also surprisingly affordable, way less expensive than takeout or those pricey delivery apps, plus it tastes way better. And now Factor also offers Gourmet Plus meals as part of your weekly options, so you can try meals that feature premium ingredients like filet mignon, shrimp, truffle butter, and asparagus. I've been really into fish lately, and I love their surf and surf option, shrimp and salmon. It's always a bright spot in my day, but honestly, you can't go wrong with their normal offerings either. Factor's team of gourmet chefs creates each meal to help you feel your best all day long, and they really are extremely delicious. And Factor's flexible. You can pause or reschedule your deliveries at any time. Now, all this is making me extremely hungry, so click on the link below or the one that's on screen and use the code LegalEagle50 to get 50% off your first Factor box and then 20% off your next month of orders. So again, just click on the link below and use the code LegalEagle50 for 50% off your first Factor box and then 20% off your next month of orders. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.